jurors present in the state's rebuttal argument.
If you remember back in jury selection, all of us agreed that when we sit down as jurors in a criminal case, any criminal case, we want to view things, number one, through the lens of the jury instructions, but number two, and just as significant, we want to view them through the lens of common sense, right? We never ever check our common sense at the door in any criminal case, or really in any walk of or aspect of our lives. So let's take a look and consider what counsel just said using that common sense. So they first told you that the defendant's wife killed Tania, okay? Or at least had a role in it. Well, let's think about that for a second, and let's use our common sense and use the evidence. So you might say, well, why would first the reason is why would she commit these killings? I mean, if you're going to kill a pregnant woman, it seems like you would have to have a pretty good reason to do that, right? You'd have to have a pretty good reason. Well, you may say, well, wait a second. Well, maybe she did. Maybe she found out that Tania had slept with Jose Soto-Escalera, right? I suppose that would give her at least some motive to kill her. But if that were true, then why would Jose lie to the police about impregnating Tania, right? Why would he lie to the police about impregnating Tania if she already knew that she was pregnant by her husband? That doesn't make sense. The wife did not know that the defendant had impregnated her, because if she had known, then he would have simply said that to the police when he was interviewed on August 25th of 2018, right? So that doesn't make sense. So we can rule that out, right? We can flatly rule that out, what the defense said. So then they say, well, wait a second, maybe Eric Alvarado did it, right? Maybe Eric Alvarado committed these crimes. Well, if you recall, remember, Eric Alvarado also has no motive to kill her, right? He's not the father of the child. There's no evidence that Eric Alvarado had ever had any type of relationship with Tania, let alone sleep with her.
Ladies and gentlemen, there's an objection. That's to this point. There's a dispute between the lawyers. You're the finders of fact, and you get to decide which side is accurate as far as what the evidence is. So I'll overrule the objection, but leave that to the jury to sort out.
Okay. So anyway, so he had no motive to kill her, and more significant, if you recall, in the August 24th translation with Rose Rosario, what does he say? Well, Eric Alvarado asks him about the blood. Did you see blood? Did you see blood? Had Eric Alvarado been there and been involved in this, he would have had no need to ask that question. He's asking the question because he doesn't know the answer. So we can rule Eric Alvarado out as well. And you also have to ask yourself, well, wait a second, the truth is, it never changes, right? I mean, the truth never changes. Well, if this were legitimate, then why are they offering you all these alternative theories? So the defense counsel also made the argument, well, wait a second, why didn't a court interpreter come and testify and translate the videos in real time, right? Why didn't they do that? Because the court interpreter is neutral. The state hired the FBI. The state hired a private interpreter. Why would they have done that? Well, there's a very good reason, and the reason, of course, doesn't come from me. The reason doesn't come from the words of the attorney, because what the judge told you, and what the judge told you right before I got up for my first closing argument is, what did he say? The words of the attorneys are not evidence, right? The words of the attorneys are not evidence. The evidence comes from the exhibits and what's said here under oath by the witnesses in the case. So let's fall back to the evidence, right? Let's fall back to the evidence. What is the evidence in this case? Rose Rosario, and I asked her, what is the difference? Tell us the difference between a translator on one hand versus an interpreter on the other. What did she say? She said, listen, there's a large difference, right? A large difference. Translators use documents and recordings. Translators have the luxury of being able to sit down and to sift through recordings and sift through evidence to make sure that they get it right, which is why that they expended so much time on the work that they performed. They have the ability to sit down and listen through it, and as both Norma Campos and Rose Rosario explained, they listened to several sections multiple times, and used, and in fact, I think 50 hours for Norma, 50 plus hours, and 100 plus hours for Rose Rosario. So they have the ability to do that, and that's what they did. Why do they do that? Because they can ensure accuracy, and they can go and re-listen to things, and they can also take into account the context of what is being said, right? Very important. Interpreters don't do that. Interpreters translate in real time. They work in real time, and they don't have the luxury of being able to refer to other parts and being able to ascertain meaning from words in that regard. So bear that in mind. Reasonable doubt. Okay, so let's talk about this for a second. Defense counsel says, well, wait a second, there's all kinds of reasonable doubt in this case. And what did they do? They pointed to two errors, right? Two errors within reports. So remember, the criminal justice system is no different than the areas where you work at, in that people make mistakes, right? People make mistakes. There is no such thing as perfection, right? Just because we haven't presented a perfect case doesn't mean that we haven't proven our case. There is no such thing as perfection, and the criminal justice system is no different. Defense counsel points out, well, wait a second, there is a typo in Dr. O'Neill's report regarding Josiah's age. The OBGYN.
As to this point as well, there's a dispute as to the facts of the case, and ladies and gentlemen, you're the fact finders, and you would resolve the dispute, but I'll overrule the objection and leave that to the jury's determination.
Okay. The OBGYN, Dr. Stossel, said the child was 32 or 33 weeks along. Dr. O'Neill said 36 or 38 weeks along. There was a several week difference. Okay, right? Dr. Stossel is going to be more accurate on that point, meaning that Dr. O'Neill had made a mistake when she had simply gone through those medical records. Does that really amount to reasonable doubt? Right? Does that really amount to reasonable doubt? Does that give you any reason? Does that give you any reason to think that Dr. O'Neill got the cause and the manner of death wrong? Of course not. Was Dr. O'Neill wrong when she said that Tania died of a head injury, which caused a skull fracture and brain swelling? Was she wrong when she said that Tania died of two significant, serious sharp force injuries to her neck? No. We're talking about a typo in her report, or a mistake in her report. Is that reasonable doubt? Of course not. Of course not. There is no requirement. There is nothing in those jury instructions that the judge read to you. There is nothing in the jury instructions that will go back with you that suggest or even approach this standard of perfection that they're wanting you to employ.
Objection.
There is no.
You can approach on that. Any comment? Of law, there, I'll ask you to not consider what was just said, and I've instructed the prosecutor to restate it consistent with the instructions I've given you. You may proceed.
So the point is that there are always conflicts in evidence in any case. The question is, do they rise to that level of reasonable doubt? And of course, the answer to this is no. Defense counsel also pointed out, well, wait a second, there's another typo in the Rose Rosario's translation on her certificate. She translated the August 24th video, and on her certificate she wrote August 23rd. Does that rise to the level of reasonable doubt? Does that rise to the level of that, those two typos, that's what you're being asked to consider? That, two typos and two separate reports, that's reasonable doubt? If you recall from jury selection, what I asked you to do is to not simply hang your hat on one or two items of evidence. If you recall from jury selection, I asked you to consider all of the evidence, right? Not just to hang your hat on one or two pieces. That's what and that's what we're asking you to do, to make sure that we could render a true and fair verdict based on the law and the reasonable doubt instruction. Remember, the defendant is the only witness in this case who had a motive to kill Tania and her child. No one else. And remember, frankly, we are not here to play the lottery with the evidence in this case, right? We look at this, we look at all of this through the lens of reasonable doubt. We know the defendant is the only witness in this case with a motive to kill her. The defendant is the only witness who had an opportunity to kill her, right? He's the only witness who had an opportunity to kill her. The defendant's the only witness who was with her on the night of the murder, and he spoke to her on the phone. And he's the only person who planned out her murder and then executed it based on what we know from the translated transcripts by both Norma Campos and Rose Rosario. Ladies and gentlemen, there is no reasonable doubt in this case. There is no reasonable doubt. All of the evidence, when taken in totality, all of the evidence, when considered by fairly and objectively and through the lens of the reasonable doubt instruction, all of it points to this defendant and this defendant alone as to who killed Tania Wise and her unborn child. On behalf of Tom Backetall, your state attorney, I thank you for your patience and your service today. Thank you so much. Thank you.
Thank you, attorneys. Members of the jury, yesterday when I instructed you on the law, I advised you that your verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. It is as follows. I know you cannot read it from this distance, but I want to hold it up and show you the form of the verdict. It's a 2-page verdict form. The verdict form has the case style on top and, of course, is entitled Verdict. It starts out with saying, "We, the jury, find Antonio Soto-Escalera as to count 1." So it's a 2-part verdict form. Count 1, page 1. Count 2, page 2. Count 1, select only one of the following 4 options: guilty of first-degree murder as charged in the indictment, or guilty of second-degree murder as a lesser-included offense, or guilty of manslaughter as a lesser-included offense, or not guilty. Then what follows on the first page is what we call an interrogatory in the law, which is a question. And it reads as follows, and it's conditional. If you find the defendant guilty as charged of or guilty of any of the above lesser offenses, you must next determine if any of the following has been proven beyond a reasonable doubt. Check yes if proven beyond a reasonable doubt. Check no if not proven beyond a reasonable doubt. And the question is, during the commission of the offense, the defendant did carry, display, use, threaten to use, or attempt to use any weapon. You would check yes or no. There again, that's conditional on a finding of guilt above. Finding of not guilty obviates the need to answer that question. Page 2, count 2, select only one: guilty of first-degree murder of an unborn child as charged in the indictment, or guilty of second-degree murder of an unborn child as a lesser-included offense, or guilty of manslaughter of an unborn child as a lesser-included offense, or not guilty. The verdict form concludes with the words, "So say we all," which highlights the unanimous nature of your verdict. There's a place for the foreperson to sign and date the verdict form before bringing the verdict form back into the courtroom for me to receive your verdict. When you come in through the door, I will look to see who's holding this paper to identify them as the foreperson of the jury, which I will instruct you on in just a second. Also, please be advised that if you are the foreperson, you're not required to read or publish the verdict form. That is the job of the clerk. So if you fear public speaking, do not let that dissuade you from being the foreperson, because you will not be required, as in some states, to read the verdict form. So in just a few moments, I'm going to submit the case to you, and I will conclude our jury instructions, as I told you yesterday, with the conclusion of the jury instructions, aptly entitled Submitting Case to Jury. In just a few moments, you will be taken to the jury room by the court deputy. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict, and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberations should stop until the juror returns. You are not to communicate with any person outside the jury about this case until you've reached a verdict. You must not talk about this case in person or through the telephone, writing, or electronic communication, such as email or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of this case. If you become aware of any violation of these instructions, or any other instruction I have given in this case, you must tell me by giving a note to the court deputy. Many of you may have cell phones, tablets, laptops, or other electronic devices here in the courtrooms. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices with the court deputy, where they will be guarded while you deliberate, if you've not already done so. If you need to communicate with me, send a note through the court deputy. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. However, please remember that deciding the verdict is exclusively your job, and I cannot participate in that function whatsoever. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. Most, but not all, of the exhibits will be sent into the jury room with you when you begin to deliberate. If you wish to examine an exhibit in evidence that was not sent back with you into the jury room, please let us know and we will bring you into the courtroom to do so. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. And as I told you yesterday, each of you will get a copy of the full instructions when you go back into the jury room. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. So at this time, with the exception of our 4 alternate jurors, the jury is about to proceed to the jury room to consider its verdict. You do not know who those alternates are. I do. So when I mention your names, you are the 4 alternate jurors. You cannot go back into the jury room with the jury at this time. So please remain there. If you have any items in the jury room, the 4 alternates, the bailiffs will get them and bring them into the courtroom for you, and I will address you when the jury goes back into the jury room. So the alternates, please remain there. The remainder, who are the jury, please proceed to the jury room. The evidence, the instructions, and the verdict form will follow.